I am Dr. Tigress Sydney Acute McDaniel, Juris Doctor, your best candidate for North Carolina Senate District 41 in this upcoming 2026 election. Not to be confused with the municipal election and, of course, the general election, which will be held on this Tuesday. Make sure you go out and do your due diligence. I will be posting my ballot picks on tomorrow. And unlike other candidates, I am not complicit, I am not complacent, and I am not shy about sharing my choices on the ballot. Where I am undecided or conflicted based on the information available to us, I share that very transparently as well. All right. And we should be voting in tandem, especially if we're on the right side of justice, because as I just reminded those on TikTok, because I'm on live on TikTok right now, at the end of the day, if we are on the right side of justice, and we are talking about just the fundamentals of civil rights and ethics, then we should be. And that solidarity is not necessarily driven only by skin folk, because we know not all skin folk are kinfolk, but it's also driven by kinfolk. So for me, I am huge on kin as opposed to mere skin, because what's going on right now is some craziness, and it is not what we need for the future of our democracy and civilization as a whole, worldwide. Okay. All right. So the reason for this particular broadcast, and I want to stay on topic in this particular broadcast, because my biggest concern is that I see that my reel is getting proper attention. I'm going to show you my reel here in a second. But it appears that still yet people don't realize the egregious nature of the crimes against me and how the recent acts of retaliation are related. Okay? So we're going to clarify this with finality. Okay. I'm going to share my screen. And I guess what I'm going to have to do is, oh goodness. Well, I don't know. There's no best, practice for this, well, I'm pretty sure there is, for those professional videographers, but for the content that I'm making right now, I don't have a best practice. So we're going to wing it and do our best. Hello, hello, hello. Okay. We're going to wing it and do our best, and I'll show you the reel, and then we'll keep it moving, okay? Yeah, this is going to be, I don't know, y'all. This is going to be difficult because you're not going to be able to see this. I'm going to have to constantly be doing this type of thing. I don't know. It's going to be weird. I need y'all to go on over to Facebook. I know a lot of y'all don't like Facebook, but I'm going to need y'all to go to Facebook, because how do let's see, hold on one second. Draw, yes, playbook, lightning. You can't really share your screen. I can flip my camera. Yeah, but I can't really show my screen, but I can definitely flip my camera. I'm going to try. We'll just work it out. It's just going to be kind of janky a little bit, because I'm just going to, it's going to be very organic. We're not going to call it janky. We're not going to call it nothing I do janky. We're just going to call it organic. That's what is real, because I am amongst the realists. Believe that for sure. All right. So let's go ahead and show this. Real. Give you my entire screen here. And let's do it. All right. So we're going to go. Okay. So it was this real. Ready?
Everybody grown until it's time to communicate, apologize, or tell the truth.
Let it play one more time.
Everybody grown until it's time to communicate, apologize, or tell the truth.
All right. Okay, so some of you, and I understand it. I understand it because it's a lot. And that's what they intended. They intended it to be a lot. That was the hustle. They wanted it to be so convoluted, so complex, if you will. And that's the definition of convoluted, that it would be difficult for lay people, people who are not as informed in law, to understand just how egregious and the extent of the criminal nature of their conduct against me, right? Some of you, at the very least, because you've seen this, you're not new to all the ick that comes in the political arena. You're not new to having learned about the injustice and the corrupt ways that are effectuated to carry out harm to others under the color of law by judges and attorneys. But I'm going to make sure it's clear. We're going to get it very clear, okay? So the way we do this, and I guess we are going to have to, yeah, we'll do it just like that. Perfect. Okay. Because you don't really need to see me. We need to focus on this. Okay. So basically, let's go back to
Everybody grown until it's time to
pause. Yeah,
communicate, apologize, or tell.
All right. And it's best to do it in this order because I pretty much did them in order. That was the intention. When I was telling you here, let's go back to it.
Everybody grown until it's time to communicate, apologize.
I was waiting for this. I need this to come up. But here in the text, the description, I tell you, here are the links so that you can see all the court records. I've organized it in a manner to make it very easy. But I'm going to do it here in real time so that it's easier for you, and we'll be able to do this very quickly. Emily Meister is the original conspirator of the Gatekeeper fraud. Okay, we need to make sure we have that clear. This started in 2013-14 when I was first running for office. I'm not going to make this long because I have some that are explainer videos that are long, but my concern is, again, that because they're so long, that you all are not getting it, I need you to get it quickly and understand just how bad what they're doing and how criminal it is. Her license needs to be permanently taken. She needs to be disbarred permanently. Same as T. Keith Black. T. Keith Black is her colleague and co-worker. T. Keith Black also served as her counsel in the case in 2013. Now, keep in mind, now all of the cases are available for all 100 counties in North Carolina on Odyssey. That's with the e-filing or e-courts integration. So now this makes it even harder or near impossible for them to obfuscate. But they have tried to do so by committing additional acts of fraud to cover up their original acts of fraud. Okay? All right. So when they effectuated the Gatekeeper order, her motivation was in retaliation against me and Alexandria Strickland, who was a guest with me at Ham's Restaurant filing assault charges against her, or a TRO against her. 50B, excuse me, a 50C, because we, of course, weren't in a relationship. Sorry for that misconfusion. That misstatement there. And so she retaliated because I was representing myself in a case against Hams for racial discrimination during the election cycle. And Alexandria was my witness. Emily Meister was mad that the judge ruled in my favor, and then she waylaid us. All that means is that she followed us out and she stalked us and harassed us as we were trying to leave the courthouse on that day. In fact, she did so to the extent that Officer Flowers, a security officer, and all of this is in even Judge Fox's order, which I will show you here in a second, which we'll reference, okay? Judge Fox talks about it very specifically, about the incident that led to this, right? So the judge who heard the 50C said, okay, you know what? Since you're a licensed attorney, even though it is very clear that you have committed an act of harassment, communicating threats, and stalking these women, and you attempted to waylay them, or you did waylay them, because assault doesn't always require a physical touching, okay? All right. That judge said, okay, you're a licensed attorney, so I'm expect for you to act like you got some sense. So she dismissed it, or effectively she denied my request because she felt that Emily would get herself together, okay? Do you think she did? No, that's the point. Not even, I want to say it was like 2-3 weeks later, if that, Emily filed a motion for a gatekeeper order against me. Okay, boom, there we are. And she was represented by her colleague, T. Keith Black. Okay, all right. So through a series of fraud and due process violations against me, that's like holding a hearing without properly regarding my rights or ruling against me prejudicially. Those are due process violations, okay? They effectuated a gatekeeper order against me, even after Judge Hennett, who's listed in here, let me go a little ahead.
That'll tell the truth.
Patrice Hennett is featured right here. I can't really get the picture. You'll be able to go back to it. Judge Patrice Hennett is right here, okay? This is Judge Fox. Judge Fox is the one who ordered the gatekeeper order and committed the fraudulent acts against me in tandem with Emily Meister and Keith Black, okay? Patrice Hennett, actually, ironically enough, she found that there was no evidence, as Emily Meister alleged, that showed that a gatekeeper order was proper against me. Patrice Hennett actually also ordered that the gatekeeper order was unconstitutional because it was being used to deny my access to the courts, basically to throw a monkey in the wrench of my litigation. Okay, all right. Hopefully this is making sense now. So now we know who Carl Fox is. Now we know who Patrice Hennett is. We already knew who Emily Meister was. We're going to go through it. I'm going to get back to it really quickly here. Okay, wait.
Everybody grown until it's time to communicate a
Okay, so where did these people come into play? Where could these people possibly come into play? This is where they come into play. So in 2016, I filed a complaint to renew the judgment that I had against Michelle Feimster Bailey, who was the bail bondsman for the 2006 case that they used to defame me. Remember how they always, oh well, she's a felon. She was convicted of attempting to obtain property by false pretenses and identity theft. Remember, I was the victim of identity theft, and I was also victim to a unjust and racist system in Cabarrus County. And I represented myself in that case, and it was like 35 charges against me. And I was able to litigate all the charges to be dismissed due to lack of evidence. And then the DA moved to dismiss the last 3 due to lack of evidence. And the presiding judge did not accept it, denied the state's motion, and then instructed the jury to find me guilty. That is not justice. That is not a fair trial. And if you look in the system at that court record, you'll see, and I just looked at it again myself, which is wild, that it shows 0 points for criminal history. No criminal history. And yet this presiding judge, this racist presiding judge, and a jury of all white men convicted me. And then this judge sentenced me to an active sentence, giving me the maximum time and running all of the charges consecutively. That means back to back. So he had the option to run them concurrently for those 3, or he had the option to suspend the active sentence for probation, supervised or unsupervised. So are you understanding how bad that situation was? The intent there was egregious, and it was to deprive my rights under the color of law. If you don't understand what under the color of law means, it means that they are denying your constitutional rights under the notion that they have some authority to do it. So basically, they're faking the funk and pretending that there's a law that applies somehow, or that they're doing the right thing under the law when they abuse your constitutional rights. Okay, so hopefully that makes sense. So when I filed the complaint to renew the judgment against her, because in this particular case, she was the bail bondsman, and Michelle Bailey, she destroyed my vehicle that I used as security. I was given a $5,000 judgment against her. I won that from an active sentence, incarcerated. So that tells you how apt I am in law. I was not in law school at the time. So obviously I wasn't licensed at the time. I wasn't a bar candidate at the time. I wasn't nothing. But I have always had strong legal acumen. Okay? All right. When I did that, evidently she called in her corrupt co-conspirator. And this is who appeared, because I actually already had a default judgment against her. I went through all the proper procedure, served her and everything, and got a default judgment against her. Keep in mind, I already had a money judgment against her. The judge had already ruled in my favor, and I had only requested $2,500 in damages to replace my vehicle. The judge was so disgusted with her behavior, he awarded the maximum amount that could be awarded in small claims, which is $5,000 at the time. By the time 2016 came around, she still had not paid the interest nor the base judgment, which totaled almost $10,000. And let's be very clear that the sheriff at the time found an account for which a levy was placed to execute the money judgment to satisfy me with the money she owed. 2 weeks later, Wells Fargo, where her bank was, sent a message to the Sheriff Cobble or Coble, that funds were insufficient to take care of the judgment. But the sheriff put a levy on the account originally. A levy is a freeze. The notes show very clearly that there was funds sufficient to cover the judgment at the time the levy was placed on the account. So and let me restart that sentence because I want it to be very, very clear. When the message was forwarded to the sheriff's department from Wells Fargo that there were no longer funds available in the account to satisfy the money judgment, it can only mean one thing, because when you put a levy on an account, by law, it's prohibited from any withdrawals. So that means that they allowed her to withdraw the money, and it was either through fraud or we know she committed the fraud, but she either defrauded Wells Fargo and they gave her money from her account without realizing that they were breaking the law, which is not likely, or they were working in tandem with her. Okay. So Richard L. Huffman, who is now deceased, he came in late in the game after I got the default judgment and moved for the default judgment to be vacated. And then moved for there to be a gatekeeper order entered against me in Rowan County, where I had filed a lawsuit, on the basis that, and his order says, his motion is where we get this original lie from.
Everybody.
He said in his gatekeeper motion for gatekeeper, Ms. McDaniel has initiated 162 cases in 72 counties of North Carolina. And because of this, 24 counties in North Carolina entered a gatekeeper order against her. None of that is factual. That is fraud. He did that with the intention to deprive my rights under the color of law. So once we're done with this, you should have a full understanding of what deprive my rights under the color of law means. Okay.
Grown until it's time to communicate, apologize, or tell the truth.
Anna Mills Wagner, and again, you can see this better on Facebook, so you'll need to go over to Facebook. Anna Mills Wagner was the judge who conspired with them. They entered the gatekeeper order in my absence, and even in her order, she acknowledges that there was a service issue. He committed sewer service fraud because in every pleading, he had my address correct, except in the pleading for what? His hearing on having a motion for the gatekeeper order. Are you feeling me? Are you feeling me? Okay. Martin McGee is relevant recently in my petition to expunge the wrongful conviction in Cabarrus County. He presides in, he's a sitting judge in Concord, Cabarrus County, and he's inserted himself into my cases in Guilford County as well. And that makes sense because they're trying to cover up all of their large scale fraud. Is this making sense? Are y'all getting this? Because we're going to end this really quickly here. All right. So we know who Carl Fox is. We know who Patrice Hennet is. Okay. And I'm trying to make sure you have the name with the faces or whatever before I go over there. So I guess I think I can do it in an additional 10 minutes because I think this is really, really getting the clarity that needs to be had. So that was in 2016. So now there's a fraudulent gatekeeper order against me in Guilford County. And then there's a fraudulent gatekeeper order against me in Rowan County. I moved to Charlotte. We moved to Charlotte in 2015. In 2018, you recall that my son was enrolled in CMS, and CMS teacher Patricia Falk admitted, the record is, it's in the record, and you can now go and look at all the cases under my name and prove and see that the proof is there for everything that I'm saying. Okay. Patricia Falk admitted to giving my son a food product with milk in it and telling him that it did not have milk in it and he could eat it. And my son suffered anaphylaxis and had to have corrective surgeries through Levine's Children's Hospital for a period of 6 months. Okay. So Lisa Bell was running for office at the time, and I was running for office as well. So they did the political retaliation and bullying again because she was trying to make herself look like she was this tough judge, and tout her abilities over mine as far as legal acumen. And they used the gatekeeper order that had been entered by Anna Mills Wagner and further used more specifically the lie that Huffman made up to enter another gatekeeper order against me in Mecklenburg County, in retaliation for my political stance against them, but also in retaliation for my complaint against CMS for my son's injuries. Now that just makes them demons at that point, because I was not, and my lawsuit did not request anything but compensation or reimbursement or payment for medical expenses and for my son's recovery and injuries to be placed in his benefit in a trust if necessary. I didn't request anything for my pain and suffering or anything like that because I didn't suffer direct physical injuries, except where I know that some of you, and I appreciate where you would concur that, of course, a mom who's being put through something like this definitely experiences trauma. And I definitely did. But I didn't sue for that. So the fact that she would, and Jamie Melissa Woods, who was the general counsel, she was one of the counsel or the attorneys for CMS schools. Okay. Jonathan Buchan as well, and oh goodness, I think he's in here. Hold on. No.
Everybody grown until it's time to communicate, apologize, or tell the truth.
Okay. Jamie Melissa Woods was the counsel for CMS. Jonathan Buchan, I couldn't find a good picture of him. I'm going to try my best, but he was the the counsel for either the Charlotte, I think it was the Charlotte Observer, because if you recall, they had actually put an article in the paper saying that Charlotte candidate, and I believe I was running for mayor at the time, Charlotte candidate sues CMS for over M&Ms, as though it was a joke, like trivializing this serious matter, which again is sick. These stories were run by Ann Doss Helms and Jim Muriel and Mike Gordon, all of them, of the Charlotte Observer. So this is why they come into play. Okay. All right. Okay. Let's go back through.
Everybody grown until it's time to communicate, apologize, or tell the truth.
Okay. That might be him. That might, because I think that I had made a mistake. I believe that is Jonathan Buchan, I think. I'm almost certain. Okay, so in another, what is called ex parte hearing, which is unlawful. You can't have an ex parte, and I say ex parte hearing. You can't have an ex parte hearing which excludes the party that would be subject to the punishment when there is punishment that could result from the outcome of the hearing. And an ex parte hearing is basically heard without the person who is subject to the possible punishment being there. So I was not there, nor was I noticed for this properly. And that's the hustle. They keep entering these gatekeeper orders without me being there because they know that y'all, they know that I have legal acumen. That's the hustle. They want to serve a fatal blow to my legal acumen. That's the whole hustle. So she entered one in 2018. And it literally says, on the basis that we find that Tigress McDaniel has initiated 162 cases in 72 counties of North Carolina, and that 24 counties have entered a gatekeeper order against her, that we're going to also enter a gatekeeper order against her. Okay. So now we go to the most recent acts of retaliation and fraud. Okay. And that was Paul C. Ridgway and Augustus Graham Shirley. Okay. So first, in order to do that, we've got to get to we've got to get to Anthony Burtz and Shamika Smith. Okay. So Shamika Smith is the one who filed the falsified North Carolina State Bar complaint against me, alleging that I had engaged the unauthorized practice of law. She was a member of my organization, the Ethical Gatekeeper. Okay. She did this in retaliation because I voluntarily complied with a subpoena for the attorney for the father of her child who has taken her to court as it relates to the custody of their child. Okay. This complaint was then used by, let's go back around. We got to go back around one more time.
Everybody grown until it's time to communicate, apologize, or tell the truth.
Shamika's complaint was used by these two judges, Paul C. Ridgway and Augustus Graham Shirley in Wake County, to then effectuate a knowingly frivolous and malicious complaint against me in tandem with the State Bar of North Carolina for unauthorized practice of law on the sole basis of Shamika's complaint. And we already know they don't really care about Shamika. They just care to have ammunition against me. So this is all this is about. I have since learned, after, being, litigated in this matter, that Paul C. Ridgway is an active executive leader for the North Carolina State Bar. So that already poses a conflict of interest. He should not be presiding over this matter at all. And he shouldn't be presiding because he has very clear bias against me. Augustus Graham Shirley has been also acting in tandem with Paul C. Ridgway. I looked them both up and I learned that Augustus Graham Shirley actually lost his race for re-election against Jennifer Bedford, a Democrat. And then he got his homies, which I reported on, Phil Berger and Howard Penny, to write him back into his a judicial seat for the same term that Jennifer Bedford was duly elected. That in and of itself is circumventing our democratic process. That itself is a facial, is a demonstrative violation of the sore loser law, or the spirit of the sore loser law, okay? Which says if you lose, you shouldn't be allowed to take a back door and gain a seat. But he did. So they're pissed off with me because of my report and that I'm not just laying down and taking it, because evidently that's what they're used to. And Paul C. Ridgway's statements in the last hearing demonstrate that what I'm telling you right now is factually, demonstrably factual. So I'm crossing out factually. Demonstrably factual, as I state, based on his own statements. I've asked for the transcript to be transcribed. I'm waiting on that, but I have the other transcripts. I'm going to now, because it's very quick, because it seems like y'all are not taking this and then going over to it. We're going to do it together. And actually, I'm going to pull it up, and then you can go on your own time and you can pull it all up and see just how bad this is. At this juncture, he's still not letting up on the civil complaint for unauthorized practice of law, and he's up the ante. And he fraudulently effectuated a first civil contempt charge against me, or show cause order against me in that same case, claiming that he had the authority without a hearing again to revise the gatekeeper order that Deborah Sasser, let's get to her, hold on.
Everybody grown until it's time to.
Right there. That Deborah Sasser copycatted in the same way that Anna Mills Wagner and Lisa Bell did on the same fraudulent information, on the same lie. Her gatekeeper order in Wake County says, because Tigris McDaniel initiated 162 cases in 72 counties, and that there are 24 counties that have entered a gatekeeper order against her, then we're doing the same thing. No, this needs to stop. That's the hustle. The lie is the hustle. And black man, Anthony Burtz, who has appeared as counsel for Shamika and Shamika's girlfriend, KJ Johnson, and their friend, Brittany Johnson, who they enlisted to defame me online. Keep in mind, I already have default judgment against Shamika for malicious prosecution and defamation. Okay? Now, let's go to, and this is relevant here as well, but then it would get longer, and I don't want it to be, I really don't want it to be that long, because I know that a lot of you are not, like, I need you to just like stick with me. It's a lot because they want it to be a lot. They want it to be so complex and convoluted that people just check out, because most people check out after 2-3 minutes of listening to something, or max out maybe even 15 minutes if it's not like entertainment per se, right? I need you to stay locked in, because they are attacking educated Black women who are on the right side of justice. And I am amongst them, okay? Let me go back to it just real quick. So, well, you already, let's go back so you can see the faces. Paul C. Ridgway then upped the ante and changed the civil contempt to criminal contempt, claiming that the emails that I was sending in compliance with Sasser's order, which directs me to email my pleadings to Kelly Myers of Wake County for the pre-filing review of my pleadings. He said, well, the emails you sent retroactively are contemptuous, and I'm holding you in criminal contempt now because you didn't show up in a hearing on December 16th, for which he gave me 4 days notice. And I had moved for continuance so that I could appear on the basis that it was an untimely notice of the show cause order. And he knew that I lived in Mecklenburg County, not in Wake County. And he knew that I had just suffered a medical crisis and was having financial hardship stemming therefrom, and so could not just afford to pick up on the fly. I also moved for appearing remotely, both which he denied. He denied my motion to continue it, and he denied my motion for a remote appearance. That shows you that he did not have good faith at all. And he keeps stating on record that somehow from his obfuscation, which is confusing the facts intentionally, that I keep showing him that I am not willing to come to court. So he preset a bail of $18,000. And I know a lot of y'all are busting out laughing at that point. $18,000, which is more than some people that are being charged with multiple violent crimes, including the case that I brought up to y'all, which is DeCarlos DeJuan Brown. So you see, that's the hustle. And part of the hustle as well now is, since I also called Roy Wiggins out for his improper bail setting for DeCarlos DeJuan Brown, Paul C. Ridgway is like, well, I'm going to up the ante again, and I'm going to demand that you appear on September 18th, for which I received 4 days notice again. I learned on September 11th from the public defender, Lucy Campbell, that my presence was going to be required on the 18th. Given the time frame and given the statute that applies for service and time, how to calculate time, the computation of time for service, the weekend would not have, those days would not have counted towards the service. And so I only had 4 days notice for that. I moved for continuance and I moved to appear remotely. And of course, we know he denied both again. And then entered an order doubling my bond to $36,000 and claiming that he would be able to hold me without bond for emails that were served in full accordance with the even still fraudulent gatekeeper order entered by Sasser. Now, thankfully, I vehemently litigated against this nonsense. Vehemently. And I moved for the recall of the writ. I moved for the recall of the order for arrest and to strike the called and failed, which is the failure to appear, which he allowed. However, I figured that he was doing so in bad faith, and I was right, because he allowed it, and then he said, but a condition of your release will be a forensic evaluation. Hold on, let me pull it up. All right, I guess I tried. This stuff is it's so much, y'all. It's hard to do it in just 30 minutes. It's hard. It's so much that's going on. But I should be able to wrap up by 10. Hold on one second. Let me get this. Hold on. Wait. Boom. All right. All right, so we go here. And if you're paying attention, then the hustle is, okay, little black girl, and more likely they call me black bitch or black nigga, whatever they call me behind the scenes, right? That nigga lawyer wannabe bitch, whatever they call me. I can just about imagine the disgusting slurs that come out of their mouth as it relates to me. And and Roy sits there, very, very likely sits there with them or over the phone or whatever, however they communicate. And he's like, yeah, get her. Wiggins, remember, is the one who failed to subject the Carlos DeJuan Brown to the forensic evaluation. And I led the charge in bringing that to the attention of the media. So this, you guys, you get it? This is my punishment. This is the retaliation that Paul C. Ridgway and Wiggins have cooked up against me. It's very obvious. It's not like, why would I be subject to a forensic evaluation? Okay, look at this. So we go here. This is the so I know y'all can see it in full on Facebook, but this is the October 27th order, and I terminated her counsel because of the ineffective assistance of counsel. We'll go over that in a separate live as it relates to Mike Howell and Lucy Campbell. I've already informed you in one regard, so you have I would say reasonably sufficient information right now, but there are more details to that. They, of course, then moved to withdraw at my direction. Let's be very clear. This wasn't like they're moving to withdraw on their own accord. This was, I have given you notice of termination, which I believe I sent over on the 11th when I got the email from her saying you need to appear on the 18th. Like, girl, what are you talking about? You don't have my best interest in mind. You're not representing me well. What in the world are you talking about right now? So the next process, because those of you who understand the procedure, this is procedurally accurate. Then after a client, which in my case, I'm a client, even though it's appointed counsel, I'm still a client. Then the attorney needs to move to withdraw themselves. So that was allowed. And that's what the emails show. Hey, I want you out. Okay. So you cool with me? This is Lucy then says, you cool with me filing the motion to withdraw? And I'm like, maybe you didn't hear me. You out. File that motion to withdraw. Get on out of here. Okay. Then you see here, defendant to represent herself and has signed a waiver of counsel. Then I had already filed my defendant's motion to strike, called and failed, and recall the OFA and OOF. Okay, and he allowed that. But again, not in good faith, because defendant's next court date is December 12th. Now, here's the hiccup too. Not the hiccup, it's the hustle. They had given me several different dates, but again, for the sake of finishing this, we will come back to this, because I want to stick with how the gatekeeper fraud is directly related to the retaliation that they are engaging right now. It is for the purpose of concealing their fraud. Okay? And so now Paul C. Ridgway wants to try to make me look like I'm crazy and paranoid, as opposed to having brought factual accounts of their large-scale fraud against me. Okay? All right. So in this regard, what I'm getting at is in open court, because they were going back and forth. You need to know the date and blah, blah, blah. Okay, well, I was given one time. Basically, the point I'm making is that they have been giving me conflicting information. Lucy Campbell has given me conflicting information. And so during the court hearing, they said December 8th. We see it's December 12th. So they did it again. Now, I've emailed the prosecutor, Patrick McCurry, and he says, oh, that just is a typo. But no, y'all want to post up on me in court about discrepancies in the time and dates for hearings. And he wants to keep pushing this narrative, this lie, this misrepresentation of my willingness to show up to court. Then this is not appropriate. You need to do better, because this is not a long form, honey. This doesn't take that much cognitive clarity to make sure that you get this right, especially considering the nature of this and the lies that you keep saying about me. So they say it's December 8th. I have Patrick McCurry's email that says that it's the 8th. And in the court record, it says it's the 8th. So I'm going to follow up with this, but just so you're aware. So he says defendant's next court date is December 12th, 2025 at 10 a.m. on the 7th floor of the Justice Center. Defendant is required as a condition of pretrial release to have a forensic evaluation done as soon as possible. Defendant is to have evaluation done at the Mecklenburg County Forensic Evaluation Unit if possible. Okay? And make sure you go and you look at all of my affidavits, and I'll go into detail about that later. And this is important as well to know that I will say this, that Lucy Campbell held out that Mike Howell was the chief public defender. She also stated that, because I asked very specifically who he was. She also said he was the felony chief for the public defender's office. And I have confirmed that through Deontay Thomas, he's claiming that Howell, but it seemed like he kind of hemmed and hawed for a second when I asked him, who is Mike Howell? So they both have claimed that he is the felony chief. I'm not facing a felony. These are misdemeanor, or it is a misdemeanor show cause order for what he claims potentially 18 counts of it, with a maximum sentence of 30 days per. So a maximum sentence of 18 months. It still doesn't make any of it a felony. And considering that none of the emails are contemptuous and his show cause order is completely malicious and frivolous, none of this holds water at all. I don't need a felony chief. Why would I need a felony chief? This is the actual chief public defender. And when I asked, because I did ask specifically if Mike Howell was the chief public defender, Lucy and Mike, Lucy, because I've not had any communication directly with Mike Howell, claimed that he was indeed. She responded affirmatively. Okay. And this is how I got it confirmed. Because I received this and I was like, oh, you thought I was going to be in jail? No, baby. No, baby. No, I'm not. When they put that out September 18th, Ridgway, his intent was to have me falsely arrested through this deprivation of my rights under the color of law. And that is sick. For a $36,000 bond. That's sick. That is the only thing for which a forensic evaluation would be merited. Then we go here, because they are related. This is what's important. So then, this is the most disgusting statement and lies ever. And that's why I am so excitedly anticipating the transcript. And we can conclude this now, because you should now have an understanding of why this all is related. I didn't just put these pictures up here arbitrarily. This is Ridgway. Based upon the observation of the court during the September 18th hearing, which he claims was 2.5 hours, okay? The court has reason to question the capacity to proceed of the defendant based upon her highly agitated demeanor throughout the proceedings, rambling and disjointed response to questions, apparent inability at times to understand the nature of the proceedings against her and the consequences of her actions, heightened sense of victimization and suspicion that all, including her appointed counsel, were colluding against her interests. Now you know that is a bright, colorful misrepresentation, intentionally, malicious, fraudulently effectuated, fabrication, all the words that mean bad. He knew, okay, I got to write this lie real good and make it stick. But he won't. Because see, you know what? And that's what I posted. And it should come full circle for many of you. You see, some lessons are like high level, and some lessons, they're as simple as G.I. Joes. Knowing is half the battle. Knowing is half the battle. Knowing is half the battle. So he says, the defendant faces charges of criminal contempt of court based upon allegations that she has violated a gatekeeper order entered by the court in response to a long pattern of similar behavior. What similar behavior? And I have already filed on record that he claims, because he claimed during the during the October 27, 2025 hearing, because I repeatedly asked just to make sure that it would be on record. Have you read my affidavits? Have you read the documentation? Have you read the case records? Have you read the records from the clerks of court from the counties that have stated affirmatively and declaratively that they do not have 24 gatekeeper orders entered against me in 24 different counties? That the only thing that they have in their counties for me at all, because they literally have no cases in their counties for which I am a party, the only thing they have is the registration of Emily Meister's gatekeeper order in as many as 72 counties of North Carolina. That was the hustle. To register the gatekeeper order in these counties, then misrepresent that I had filed cases in all of these counties. No. And they went so far as to keep their lie afloat. They had it registered and clearly told the clerks to put it in as though I was the petitioner. I'll show you one real quick and then we'll end here. The ridiculous part about that is that how would I logically be the petitioner? That's the person who wants this on record. How would I be the petitioner in 72 counties and voluntarily want them to register a gatekeeper order, the copy of the great gatekeeper order from Guilford County in all of these counties? Y'all, come on. So who crazy? It ain't me, honey. It ain't me. And you can't flip that on no day of the week, but they trying real hard. They want to get a rise out of me. But you see, you can't get me out of my character because that's my character. And so what he's trying to say is, she was highly agitated because I got him straight. I spoke to him and I spoke to his spirit as well. It is highly inappropriate for you to be this disrespectful to a fellow Juris Doctorate. It is highly inappropriate for you to be this reckless with how you have looked and considered the facts of this case and the records, the case records that very clearly show that I have absolutely no history of abusive litigation. That there are not 24 counties that have a gatekeeper order against me, as the lie goes. That I have not filed 162 cases in 72 counties. You can't dispute that. And yet, he's still going on. Still pushing this narrative. That alone is the only thing for which a forensic evaluation is necessary. And I don't know if he's on the ballot in Wake County for this upcoming election cycle, but you all need to unseat him in Wake County because he's a danger to us all. Don't believe, like we tell y'all, injustice in one place is injustice what? Everywhere. And if he feels emboldened that he can get away with what he's doing to me, he will feel emboldened to do it to his own white, cis male counterparts as well. Well, they're not counterparts, you know what I mean. His own white, cis male peers as well. Because this is about power and corruption. And he's saying that I'm making Oh gosh, I'm eventually making it up that they're all against me. How cute. That's cute. All right, so let me go here and just show you this, and then we're going to end. I'm going to go into, oh, and then let me show you this too. Let me go to it real quick. Well, no, never mind, because I'm going to do that later. Let's go to the gatekeeper order. So this is that case. Remember, it's right here. Okay. And I've already gotten, it's the same case. So don't get it twisted, it's the same case. I guess he was, I'm going to try to give the benefit of the doubt because there was a bond forfeiture that they put in the system on the 31st. So they didn't put it, when there's a bond forfeiture and the order for arrest is recalled, they're supposed to simultaneously set aside the bond forfeiture. But ironically enough, the order for arrest was set aside on October 27th, and then the bond forfeiture was entered on Halloween. Yeah, don't play no games. I already emailed the bail bondsman. I'm on top of it. I'm on top of it, and I'm staying on top of it. Okay? Because their games are failing. Now this, because, let me go back to it. I thought this was disgusting too, because again, this is part of the hustle. Because they want something against me. They need something, anything, something, they need something. Right here. Okay, so this is the local capacity to proceed evaluations general instructions. Why are they doing this again? Incorporating my birth name. This name has been defunct for 22 years. 22 years. I haven't used it for any purpose except for behind the scenes, like when for legal purposes, like if I'm trying to think of an example where I had to use it. I think with my medical records here recently, I had to refer to some with regards to when I had fibroid tumors and things like that. Okay, so, but yeah, generally everything, all of my records have been updated to reflect my legal name change, which occurred in 2004. And then, of course, they're back to the BS, prior legal history, that. None of this is relevant to this show cause order for sending emails in compliance with even the fraudulent order that Sasser entered, okay? None of it's relevant. So I emailed Patrick McCary, and I said, having now received your documentation for the forensic evaluation purporting an alias for under my defunct birth name and thus my former name, and that I haven't used it since it was changed in 2004, as opposed to the connotation for alias, although understanding where the term can be used interchangeably. However, considering that my identity is evidently in question, and that's the reason why, and we'll go over Howell, that's another reason why I put Howell on the street. You're not representing me because you're in here. He literally, during the September 18th hearing, he told Paul C. Ridgway, and you can tell that they were cooking up something. He told Paul C. Ridgway in open court that he questioned my identity and that he needed to eyeball me. My dude, you are not a psychologist. My dude, you don't qualify on any day to vet me on any day, not in any regard. Not in any regard. And that is where knowing is half the battle. But I'm not going to disclose that here because they are watching me very, very closely. And I'm not going to give them a litigative come up with their corruption because they intend malice. And Lucy Campbell said severally during the October 27th hearing, oh, she has made it very clear that she does not want us representing her on her Facebook post, and blah, 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 her Facebook post, and blah, 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 her Facebook post. Right. Thank you for confirming what I already knew that you were watching. So again, be very clear. Lucy, Mike, Paul, I am not scared, and I said this even on record, because I have done nothing wrong. I'm not saying that I'm not scared because I'm all big and bad. I'm saying I'm not scared, and why should I be? Because I've not done anything wrong. Why would I be scared when I've done nothing wrong? So I'm not scared that you're watching my public platform because, duh, it's public. And I am a staunch anti-corruption politician, so that's what I report on. It's simple math. We're going to get on out of here. So I moved the court. I said, based on the fact that y'all, my identity is evidently in question, and incorporating my assertion that you've added my defunct birth name in bad faith or under misinformation stemming from Howell's misrepresentations to you and the court, I've moved to strike my defunct birth name accordingly. You should have already received service for that pleading. I lost personal legal records in a fire a few years back and have only an electronic copy of my revised birth certificate and the Social Security Administration letter verifying the issuance of my new Social Security number attached. Y'all should remember that story as well. That's on my YouTube. It's in Facts About Me, something like that. And many know that I was a victim of identity theft myself in 2004. I didn't even know you could get a new Social Security number, okay? I am very savvy in so many different aspects. But honey, I remember, I will say this before I go, because that definitely, that was a very interesting experience. Very interesting. Now that was scary. That was very scary. Even though I know I hadn't done anything wrong, I was like, it was scary because I was like, what in the world? So I worked with Louisville Police Department with regards to the remedy for the identity theft that I had suffered. And I got a letter in the mail. And I remember the letter told me that I needed to surrender my Social Security card to the local office and when I was in Louisville. And I was like, what? And I remember telling my mom, and I was like, what does this mean? I was still in my 20s. I didn't know, I'm a lot of things. And we say that, for those who don't understand that, because again, we know that the bad guys are watching, so they're going to take stuff out of context. When we say all things, we are all things, it means that we are qualified in many different areas. And remember, I don't code switch, so I'm not doing this for their benefit. I'm just doing it for the record, okay? And so we all know I'm smart. We all know I'm intelligent. We all know that I'm psychologically competent. They don't know to what extent. Some of y'all already know my credentials. So again, like I said, they're barking up the wrong tree, and knowing is half the battle. I did not know, had no clue that you could actually get a new Social Security number. That was not even nowhere near on my radar at all. I was just going ham, working with the credit bureaus and everything to get everything, and check systems and all that kind of stuff to get everything straightened out. And I mean, that was like one of the first times I became like a ninja with making sure that I stayed on top of stuff, because everything was being impacted. My credit, my my rental credit, even not just my personal, like regular credit. And I went there very reluctantly. And I was scared. I won't lie to you. I was scared. And I remember sitting and waiting for them to come out. And I remember, I believe it was a man, and he came out. And when I tell you, he was just the calmest, he was so kind, very professional. And he just simply, because I think I had already passed along my Social Security card to the window. And he gave me a letter. And he said, you'll receive your new card in the mail 7 to 10 business days or something to that effect. And I was like, huh? And he was like, okay, well, have a great day. And I was like, have a good day. And he walked off. And I remember sitting there for a while, like, what? And then I had to go through the process of working with the SBI and even DMV, because we were trying to figure out what to do. I remember there was like procedural issues with regards to my driver's license number, because that had been used for obvious reasons. So, with identity theft. So my driver's license, I was issued a new driver's license number. And of course, behind the scenes, the authorities can see that. So let me make sure it's very clear. Much like an expungement, some people believe that if you get a crime expunged, that it is deleted literally. It is deleted from public view. It is not deleted from authoritative records. Authorities can access it because, for obvious reasons, if you get something expunged and you go out and commit the same type of criminal behavior, we have to understand that it will be used against you because you're committing the same type of behavior. So it would be probative or relevant to your conduct that's in question. You know what I'm saying? So behind the scenes, the authorities who are supposed to have it, they have my original identifying documents, and they have them cross-referenced with my current ones. And there you have it. So it actually makes Paul look really, really loonball for him to incorporate my birth name and incorporate these things because of that very specific and widely known fact for those in law enforcement and law. Like, I mean, he puts on that he knows the law up and down, and he puts on that he knows the law better than me, as you see, because he keeps talking to me in a very disrespectful manner and insulting my intelligence and my psychological competence by saying that he feels that I don't understand the charges against me. And my response is, I don't understand how you raised the charges in the first place, homie. Okay. But yeah, so basically, and I had to get this. I wanted to add this. So this was me making sure to add all of this. Let's see here. And I also, as you can see, like I told you, I also asked him, Patrick McCreary, the prosecutor on the case. The order reads December 12, 2025 for the next appearance, as opposed to December 8th, per my pending motions and inviolate jury trial demand, which I demanded. I deduced that my motion to return show cause order before another judge, renewed pro se, will be heard on December 12th or December 8th, as you and Ridgway originally announced in open court. Please confirm in that I'm currently budgeting and planning to commute and definitely trying to reserve a decent hotel this time, which of course, requires advance reservations. The hotel we had, trash, just let me know, just complete trash. So then his response was, and I found it very interesting. And he goes, he's very specific. The state did not make the motion for you to be evaluated for mental capacity. The court did. Therefore, the state had no role in drafting the order, and my signature is not on that document. Thus, the state did not use your birth name in bad faith or under misinformation. And I was like, okay, boo. So I said, thank you for the clarification. But then I thought, he's probably thinking, I don't understand. No, my response like that is it's just being professional, honey. So I made sure to send him another email. I want to make sure this is also on record. And in response to the other documentation they had sent, I responded to Patrick, as you see, it's Patrick. And I said, Patrick, I've received it, because he received a copy of it as well. This is from Tammy, who's with the courts. And I said, again, based on your open court statements and your prosecutorial role, I deduced that you were acting in tandem with Ridgeway, which was proper. Again, thank you for clarifying your disposition, albeit only in that specific regard. So that's where we're at, y'all. That's the meat and potatoes of it. Hopefully it should now make so much more sense. I'm going to go and have breakfast because I decided to do this first. I may not even need to go live and do the other one just yet. Because I think that I gave you all the puzzle pieces to make it make sense. So that's why that specific set of people that I show in that reel are relative right now. None of them have any mitigating circumstances, especially as it relates to even Patrice Hennett's recent conduct during the hearing before William A. Wood, who's also featured there, as to Emily's and T. Keith Black's effort to try to get the gatekeeper order entered or escalatedly made permanent, which was denied because that is not the law. You can't have a permanent gatekeeper order. That's not what it's for. That's the forensic evaluations need to be done with Emily Meiser. They need to be criminally prosecuted. And again, I have already agreed to cooperate with the Federal Bureau of Investigation as a prosecuting witness. I am not joking about that. That is not a bluff. I do not bluff. I don't bluff. Now, I'm not an FBI agent, so I can't go and arrest them. If I could, I would have already done it by now. Long since before now, I would have already done it. I don't have that authority. That's not the capacity that I'm serving in. I am being a willing prosecuting witness for the FBI. They have to conduct their investigation and I have to go through their process, and that's that. But that's where I'm at. So thank you so much for your time and thank you so much for your ongoing support. And I'm definitely going to need your support in this upcoming election cycle because they've upped the ante in their attacks against me and other highly educated Black women like myself. And I guess I'm getting the brunt of it here because my education and my qualifications and my competency, albeit psychological or academic or leadership wise, is unrivaled. So clearly I am the target. All right. Well, thank you again. Y'all have a wonderful, wonderful Sunday. And I'll be in contact again. Like this is a face call from vlog. I'm going into like the vlog mode. I love it when the vloggers have that FaceTime sound where you end the call and goes, whatever. I can't make it right now, but I love that. But yeah, so I'll be in contact, and I'm thinking about scheduling some office hours here in Charlotte and some town halls. We're going to figure it all out. So stick with me, get locked in, follow me on all socials, subscribe to my YouTube channel at C Tigress Run. Bye-bye. Bye. An hour and 26 minutes. I swear for God. I swear for God.